Start. He has relied upon the decision of Calcutta High Court in case of Amit Kumar Gupta versus Deepak Prasad 2021 SCC online CAL 2174. Relevant paras 17 and 18 of the judgment are extracted here as under. The meaning of the word court as prescribed in section 2 within bracket 1 within bracket E of the Act 1996 is subject to the retirement of the context. In the context of section 29A of the Act of 1996, which has prescribed a substantive provision for completion of the arbitral award and the time limit to do so, the meaning of the word court as used therein has to be understood. Under subsection 6 of section 29A of the Act of 1996, the court has been empowered to substitute the arbitrator or the arbitrators in reconstituting the arbitral tribunal if so required. The power of appointment of an arbitral tribunal has been prescribed in section 11 of the Act of 1996. Section 11 of the Act of 1996 has prescribed two appointing authorities given the nature of the arbitration. In the case of an international commercial arbitration, the authority to appoint an arbitrator has been prescribed under section 11 of the Act of 1996 to be the Supreme Court. In the case of a domestic arbitration, section 11 of the Act of 1996 has prescribed that the appointing authority shall be the High Court. In my view, the word court used in section 29A of the Act of 1996, the character of the appointing authority has been prescribed in section 11 of the Act of 1996 as the court exercising jurisdiction under section 29A of the Act of 1996 may be required to substitute the arbitrator in a given case. Such right of substituting can be exercised by a court which has the power to appoint. The power to appoint has been prescribed in section 11. Therefore, the power to substitute should be read in the context of the power of appointment under section 11. Power to extend the mandate of an arbitrator under section 29A beyond the period of 12 months and further extended period of 6 months only lies with the court. This power can be exercised either before the period has expired or even after the period is over. Neither the arbitrator can grant this extension and nor can the parties by their mutual consent extend the period beyond 18 months. Till this point, interpreting the term court to mean the principal civil court as defined in section 2 would, to my mind, pose no difficulty. The complexity, however, arises by virtue of the power of the High Court to substitute the arbitrator while extending the mandate, and this complication is of a higher degree if the earlier arbitrator has been appointed by the High Court or the Supreme Court. Coupled with this, one cannot lose sight of the fact that the legislature in its wisdom has conferred the powers of appointment of an arbitrator only on the High Court or the Supreme Court, depending on the nature of arbitration and as and when the power is invoked by either of the parties. There may be any cases in which, while extending the mandate of arbitrators, the court may be of the view that for some valid reasons the arbitrators are required to be substituted, in which case the court may exercise the power and appoint a substituted arbitrator